Good morning, everyone. Today is March 15th, 2022. We are meeting remotely. This is the Incarceration Prevention and Reduction Task Force Joint Behavioral Health and Legal and Justice Systems Committee meeting. And we're joined today with our Stakeholder Advisory Committee members as attendees this morning. Before we begin, I'd like to acknowledge that we are gathered on the traditional and unceded territory of the Lummi, Nooksack, Samish, and Semiahmoo people who have cared for and tended this land since time immemorial. Truth and acknowledgement are critical to building mutual respect and connection across all barriers of heritage and difference. We begin this effort to acknowledge what has been buried by honoring the truth. We pay respect to their elders, past and present. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that brings us together here today. And please join us in uncovering such truths at any and all public events. And with that, I'd like to go ahead and call this meeting to order. Raylene, it's all you.
Thank you. I'm looking for Susan Copeland, and I don't see her on my screen. Jill, can you let me know if anybody from the DSHS has joined us?
Yes, we have, where was she? She was just here. Darla Dawson is here.
Hi, I'm here. I'm not sure if Susan will be able to make it, but hopefully she will, but if not, I'm here.
Excellent. Sorry, I see Tom Kinlan's down there below too. So I just wanted to make sure before I started going through our agenda items, make sure I had some people here to help me out. So we met at the last joint meeting and discussed some of the issues. And then I also had a separate meeting with Dr. Nygaard and Susan Copeland on the cell order and some of the other issues that we're having. And so we wanted to kind of come back in and regroup with everybody. Some of the individuals on the committees weren't able to attend at the last one. So I'd like to welcome Darla Dawson with DSHS as well as Tom Kinlan. And if we can discuss the cell versus United States. Some of you might be familiar with this, some of you may not. And then is Whatcom County in phase 3 of the state's outpatient restoration program was one of the questions, and current jail information on inmates who have to go to Western State and a percentage of inmates with mental illness. I'm going to start off by asking Darla or Tom if either one of you could give us a brief overview of cell versus the United States.
Hi, this is Darla, and respectfully, I'll defer to Dr. Kinlan because I think he can speak to that better than I could. Thank you.
Sure. Hi, everybody. Tom Kinlan. I'm the director of the Office of Forensic Mental Health Services, and I see some familiar faces from December. So thank you guys for having us back. I appreciate that. So I wasn't at the presentation previously, so I don't know what was covered, but if there are questions from that, I'll definitely try to do my best to answer them. But generally speaking, what we're talking about with cell, and I will really make this a 40,000 foot level just because that's how it helps me to understand. And I just think I just saw Susan join, so I'm going to pause for a second because I don't want to usurp her presentation. So Susan, are you able to hear me?
Yes, I can.
Okay, wonderful. We were just going to start talking about cell versus United States. And I said before I got into, since I wasn't at the last opportunity that you met with some of the staff here and stuff like that, that perhaps if you want to go first and I can kind of fill in gaps or answer questions or anything like that. Does that make sense? Or did you want me to go ahead?
Why don't you start? Because I wasn't at the last one either.
Okay. All right. Well, we'll just go round and round. So I'll go ahead and just talk about it. Okay. So cell versus United States. Okay. So what happens is obviously individuals get evaluated for competency to stand trial. And then from that evaluation for competency to stand trial, where we're going to look at, are they able to basically understand the proceedings against them, and are they able to assist in their defense? Those are kind of the two prongs that we're looking at for competency. So forensic evaluator, usually a PhD or PsyD psychologist, will complete a report and then provide an opinion where they'll say generally one of three things. Person's competent, which generally means, hey, they're going to go back in front of a judge, have a decision on whether they are competent, and then proceed to their sort of guilt innocence phase. 2, competent, not restorable, which could lead to dismissal of charges, could lead to another evaluation, some things along those lines. Or 3, give an opinion that says competent and restorable. And so competent restorable right now leads to a couple different pathways. One being the one you guys would be the most familiar with, going inpatient to Western State Hospital or Eastern State Hospital, or one of our 2 current RTFs that Susan oversees. There's the Maple Lane facility and kind of the Rochester, Centralia area down I-5. And then a bit further up I-5, there's the Fort Silicon one that's in the Lakewood area on the campus of Western. So that would be the inpatient services. Hey, somebody's going to go there for competency restoration treatment. Kind of related to that second question, then we do have 10, soon to be 11 counties that have outpatient competency restoration related to the contempt settlement agreement. So when an individual then is in restoration, the number one, and it's not just Washington, it's across this entire country, probably other countries as well, but definitely in the United States, the number one treatment modality to restore competency is medication. So medication is going to be attempted. And so when we have individuals admitted to the facility, we'll work with them and see if they will take medication voluntarily for competency. And if they agree, everything is wonderful, that's great. They start taking medication. Hopefully they have a positive response. They're found competent, and then they can return back to their county of origin and face their legal charges. Sometimes what happens is an individual refuses to take medication. So they say, nope, I'm not going to take any medication. And they're not a danger to self or others. Okay, so they're not actively trying to hurt themselves. They're not gravely disabled, where we would do, say, forced medication on that front. Think of that criteria that would be very similar to the Involuntary Treatment Act, right? So they're not doing that. They're just, refusing medication, maybe still having lots of positive symptoms, but they are eating fine. They're not hurting themselves. They're not getting in fights or anything like that. So we wouldn't medicate them. CEL is a process that would allow us to force medicate specifically to restore competency. So there is a process that you have to go through to make that happen. So it's think of a general legal process where usually at the facilities, they would make a request, I think generally notifying both parties, but I think the prosecutor is going to take the one to run with it, because they're going to be the one that needs to basically show the compelling state interest. They need to prove their case on why this person needs to be medicated for competency. So the facility would reach out to the parties, and they would say, hey, Mr. Smith is not taking medications, and we would request a CEL hearing to see about medications for restoration of competency. And so that is kind of in the prosecutor's court to determine what they want to do with that. If they want to move it forward, they would have a hearing scheduled, a CEL hearing, where they generally would call the treating psychiatrist. That's usually the number one witness that would be there, because the questions for CEL tend to relate to kind kind of the medications, are they not causing harmful side effects? Are they sort of the best course of action? Because CEL really is like 4 prongs, and I don't have them memorized, so I apologize. Some of you on the call probably know it better than I do, but generally the state needs to show a compelling state interest of why we're going to medicate this person against their will, to find them competent, make sure that the medications aren't harming them, are sort of the kind of least invasive process and so on as it relates to medications. And so they'll have that hearing, psychiatrist will be the witness, kind of testifying, and then obviously at the end of the hearing, the judge will make a decision on whether they're going to force medicate or not. And then from there, if the facility, if the judge orders forced medication, that order goes to the facility, and then the nursing staff, direct care staff, psychology, psychiatry, generally would work with the individual, saying, now we do have an order to treat. And so work with them on hopefully taking the medication without any challenges as easily, as quickly as possible. In full transparency, unfortunately, that's not always a smooth process, and it might require a manual hold of some sort to administer the medication. Thankfully, in our residential treatment facilities, that is a few and far between where it does occur, but it does happen at times for that individual to get the medication. And of course, at that time, they're taking the medication via intramuscular injection. And so that is that kind of general process. Timeframes on that can be fairly long. Facility might make that request. It might take a couple of weeks, sometimes at the quickest. So I've heard is anywhere, and Susan can obviously correct, about 2 to 6 weeks. A lot of times the individual is being transported back to jail for this hearing. And of course, sometimes they get transported and don't come back because maybe the case is then dismissed, or usually that's the option that might happen while they're back in jail. Obviously, if they are found to meet the criteria for CEL, judge agrees, they would go back to the facility and receive treatment that way. So that is kind of a 40,000 foot overview of kind of the CEL process. I don't know if Susan wanted to add anything from the RTF perspective.
I think from the RTF perspective, and I know we had a meeting, Dr. Newgard and I from Maple Lane had a meeting with Raylan, what was it, a month ago, to discuss it, because there were some glitches with Whatcom County, and I checked in with Dr. Newgard, and I think he's on this. I think he's listening to us right now. And he agreed it's gotten better. So he's still watching it, but it seems like we've seen improvement since that conversation. But sometimes it's just, we had one prescriber, she's no longer there, she retired. She'd called it wasted bed days. When you have these patients that are waiting for that CEL order and you really can't progress with treatment, there's not a lot we can do. I mean, we still have them go to group. We still have them do that if they're willing and safe to do that, but we really depend on that medication. That's why it's really hard to treat the misdemeanors and the RTFs, because it's a process, as Tom explained, to get the CEL order. Once we have the CEL order, the patients are always given the choice. They're explained, they're shown the order, they're shown you can take it by mouth or by injection. Sometimes the patients prefer the injection in the beginning. I've never understood why, but sometimes they will, and it's not even a manual hold. They'll just hold out their arm and say, I want it that way. So sometimes you'll see in their records where they've had injections, and if it doesn't say manual hold, that often means it was by choice. But the staff are very skilled at talking to them and explaining what the CEL order is once it comes through and what it means. And we try everything we can to avoid those manual holds.
Thank you, Susan. I see Mike Parker and then Dan Hamill.
Thanks so much to both of you for the information. I think it's a window on stuff that we don't often get to see. But it did beg a question as I was listening, Thomas, to you and then Susan afterwards. Sounds like there's obviously some of that time, and Susan, you termed it as wasted bed days. And I know that there's a physical transport to jail. And this is probably not the first time this has been asked of you, so apologies if it's redundant. Is it possible to make that virtual? Can these people show up to court in a virtual type of setting? And would that be an opportunity to reduce some of that time? I'm just thinking that the person obviously is not in great comfort in your facility, being unmedicated, maybe having a thought disorder, right? That's probably miserable for them. And it's also very difficult for the justice system. I'm just wondering if you could comment on that.
It is miserable. I mean, I do feel bad for the patients because you can tell it is miserable. I mean, they're ill. And since COVID has hit, the one positive out of it is more and more courts are using the telehealth equipment that each RTF has. And we'd be more than happy to do these over video instead of waiting for transport, because I agree that does lengthen the process. And we are set up to do it at each RTF.
Are we set up and welcome to work with you in that way, or do we need to do something on our end?
Do you have the equipment? That's my question for Whatcom County. Is there telehealth equipment available for the attorneys and the judges to use?
Wendy, could you respond to that? Go to Dan after we're done with these questions.
Hi, Wendy Jones. I'm chief of the county jail. We have the telemedicine equipment here in the jail, and I know that frequently they will do cell hearings remotely. And so I'm assuming they have a connection in the courtrooms, because I go looking for those in the Odyssey system, and there have been notations that we haven't had to move the offender back up here for that hearing. Every once in a while, we'll get somebody who will demand that they be able to come to court physically, and we try to accommodate that. So.
And I know in the past, I don't know if we've done it with Whatcom County, other counties will do it via phone too. They'll have the prescriber testify over the phone.
And that may be one of the alternatives. Maya, you probably know better than I do.
That's true. I've had cell hearings with the provider appearing over the phone, and I've had them where the client appears over the phone as well.
Mm-hmm.
Dan?
Thanks for the presentation here this morning. Two questions. One is race and ethnicity data collected at residential treatment facilities. And two, is the treatment provided for mental health illness only or for substance use disorder treatment as well?
For the substance abuse, we're not licensed to do SUDS, but I will tell you both programs do like AA meetings. So Fort Steilacoom has someone who virtually Zooms in from the community, and they run them. At Maple Lane, there's a peer support specialist who runs them. So they have AA, and it's more educational based because we're not licensed to do the SUD treatment. And now I forgot your other question. I'm so sorry.
It's okay. Just was asking about race and ethnicity data being collected at RTFs.
I believe RDA collects that. I could just do a ticket request because that's part of like the admission packet when they come in.
Yeah, so just further clarification. So RDA would be our research and data analytic team. So they're in the DSHS, and so they would be the ones that would be able to provide any data, or if there were data requests on that. And the other piece, I think as well, Susan, correct me if I'm wrong, does AA come into some of the facilities as well?
They were prior to COVID. So now, like at Fort Steilacoom, it's virtual. I don't know if that's going to change now that the mask restrictions and things are starting to loosen up, but we were able to use the telehealth for that purpose.
Thank you, Stephen. And then Mike again.
Thank you. I think it was you, Susan, who referred to some problems with Whatcom and some recent interventions that have made improvements. For those of us not in one of these systems, there's a lot left out of that. Could you explain what our problems were? I'm assuming they were time lags at least. And can you explain how bad they were? What improvements are you seeing in that area? And anybody locally who can describe what changes we made that led to those improvements would help us understand the process a little better.
Yeah, and if I get this wrong, I hope there's some way Dr. Newgard can help me because it was based at Maple Lane and he helped with the meeting with Raylan, but it had to do a lot with timelines. Like we send the request in and then there was a delay in hearing back. And sometimes there's a delay in setting the hearing. And if you're on a 45-day order, that clock is ticking. So the later we get the meds within the order, the less successful it may be for that patient. And we really pride ourselves at the RTFs on trying everything we can to help that patient become competent. So speaking to Raylan, and then when I checked in with Dr. Newgard last week, he said things are improving. I don't think we've had that many Whatcom cases lately, but I'm keeping a pulse on it. And if I hear that it's going backwards, I'll let Raylan know right away so there can be an intervention. I was really appreciative when these meetings started because that would open the door for these conversations.
And is the improvement, is that because of our judiciary acting differently, or Eric or Maya? Do you know anything from either side that you're involved in?
My recollection is that we've had some communication problems, some communication that people needed to have a cell hearing, and you know, that'd be back and forth between the hospital and the prosecutor's office. We didn't know that we needed to set a hearing, and I think that's what Dr. Copeland's referring to. Am I correct about that?
Well, I'm not a doctor, but yes, you're correct about that. And I think, you know, the communication, I mean, Raylan reaching out to me, that has helped a lot because now we have a contact at Whatcom if all our other contacts fail.
So you say Raylene, and Raylene works for the city of Blaine. So you need to have a contact within our office, and maybe we can set something up for that.
Yeah, if you could give me a direct contact, that'd be awesome. I'd really appreciate it.
Okay.
I'd say that like delays from the defense perspective may come when we need to retain a doctor to talk about side effects from medications that are impacting our client. And that requires some time for us to locate, retain, and then schedule a defense expert to counter the state's request to involuntarily medicate our clients with medications they're opposed to. So that can cause delays sometimes, but that's just sort of the practice. That's not like a scheduling or overlooking thing. That's just part of it.
Okay. And Dr. Newgard just sent me an email, so he is listening.
Oh,
So
I think someone allowed me to unmute now too. So
oh, okay. So there you go, Eric.
all right, thank you. We haven't had many Whatcom cases in the last couple months that I can recall, other than we have one pending now, but that gentleman is on his way somewhere else. A couple of the challenges we've noticed in the past are difficulty having, if for instance, the defense attorney is out on vacation or something, not having a stand-in secondary attorney. So we've had delays that way. And then we've had a couple times where it seems like judges, and I don't know why, I'm not second guessing, just observing, have taken like more than a week or two to like study case law and things like that. And while thoroughness is appreciated, we on our end, of course, have a patient suffering. And then probably the third thing I've noticed is just speed in which communication back and forth seems to happen. And I don't know which end that may be on or what other factors are in play, but that's just an observation I've noticed.
So Raylene, I wanted to add one more thing to this discussion so that everybody here knows that the first factor for cell hearing is a finding that there's an important governmental interest in receiving this injection. And the reason why that's a factor and why that's important and what it really means is that misdemeanors are typically not considered to be important governmental interests. So we're talking generally felonies. We're not talking about all felonies, but generally, you know, felonies and more serious felonies are considered to be more important governmental interests. So I just wanted to give that clarification to everyone here on this panel.
Thank you, Eric. And just before I go back to Mike and Dan, I wanted to make a note. I met with Susan and Dr. Nygaard about a month ago, We kind of discussed the cell order and the Harper decision. And essentially my reaching out was to open the communication with everybody in the group and to try to resolve some of the issues. Obviously, this is way bigger than all of us to fix all of the problems. But I think everybody in this group has something to participate that can help try to alleviate some of the issues, and bringing it to everybody and opening the communication is kind of what I was trying to do, is to make sure that they had contacts and names with everybody. So that's kind of where I was going. And Susan and Dr. Nygaard did mention before, one of the other issues was what their dream was to have a psychiatrist into each county to assist in these areas. So I don't know if that's something we can do, but that was just something that they mentioned that I wanted to make sure that we brought to the group. And then I saw Mike Parker and Dan Hamill's hands both go up. I think it was Mike first, but I could be wrong.
Yeah, thanks, Raylene. And thanks again to our presenters and for being so flexible with all of our questions. So obviously with substance use disorder, and this is what my line of questioning is about. So I understand that is probably a bigger juggernaut to not be licensed to be able to treat for SUDs, but a clarification question. So if we have somebody who is addicted to opioids and has prescriptions for Suboxone, does that mean that that person can't be subordinated? For example, I know our county jail is now able to help inmates if they have that. How does that work if you don't have an SUD license? How do you help people that maybe need medications as part of their continued recovery and sobriety plan? That would be question one. Question two is, what's the potential, or are you already, or is the system eyeing a change in that? Because we see, even higher than what you read about in all the literature, we're seeing above 70%. If you come with a serious mental illness, you're going to have a co-occurring substance use disorder. I think we see closer to 80 or 90 in Whatcom, and that's certainly anecdotally we hear from law enforcement too. So I'm just curious if you'd comment on, one, what do you do now? And two, what does the future look like?
What we do now is Fort Steilacoom recently, both their prescribers went through the program to get the waiver for Suboxone. So they're able to treat it. I know Maple Lane's unique because the clinical staff is contracted through WellPath and they're working on it. So they're not quite there yet, but they are working on the waiver to have the certification. We are part of the True Blood settlement. So we have the court monitors on a quarterly basis who come out with her team of experts, and they have been pushing for SUD treatment. I would say, we're exploring it for Fort Steilacoom. I don't know for Maple Lane because they have a hard closure date of 2024 based on the settlement. So if I was going to explore it, it would be for Fort Steilacoom because there will be the RTF that will remain open for Competency Restoration. But I am working on the waivers for both programs.
Thank you, Susan and Mike. Dan?
I thank you, Raylene. Pardon me. I share Mr. Parker's concerns regarding substance use disorder, in particular with the new drugs, or not new anymore, P2P methamphetamine, benzodiazepine mixed with fentanyl, carfentanil. These are real problematic. Very concerned about the meth and the lack or the dearth of treatment options. I've heard Vivitrol being thrown out. My understanding from Chief Jones is that that option is not being exercised by people exiting the jail upon leaving. So I just want to have that comment briefly. My question is in relation to that sort of. It seems like people are navigating several systems here. They're navigating courts, jail, RTFs. They're talking with police. They're talking with defense attorneys and prosecutors. Is there a formal system for aftercare as relates to people who have entered your system, and when they have their cases resolved and they're through with that part of it, what happens to them in terms of patient outcomes, recidivism, and community safety?
It's a great question. And that's one of the mysteries I've been tasked to solve by the court monitor and our experts is discharge, because once they leave my The RTFs are out of my legal authority, but I do have the social workers who are in a subcommittee. And if anybody would like to join that with ideas, I would appreciate it. We're trying to figure out what's the best discharge summary, how many resources can they set up on our end? Because we reach a lot of roadblocks because they're in residential. They don't qualify for the forensic HARPs, which you would if you're an outpatient. And then there's a lot of systems we can't access while they're still in our care. So they have to be released from jail, but we're trying to figure out what would be the most beneficial in that discharge summary that the residential treatment facilities send out for the jail, so that torch, it would be a nice warm handoff between the RTF and the jail so that the patient doesn't get lost in the system and end up back. I will tell you, there are a lot of patients that come back to RTFs. I don't have the data in front of me, but you know, we have a few that really know us all by name because they've come through a couple times.
Yeah, and this is Tom. I'll just put a bit of a finer point. And I would say not just for Whatcom, that's for the entire state and of course the entire nation as well when it comes to competency. So Dan, to answer your question, no, there's not like this is your standard kind of release plan that this is what you're going to be connected when you go through a residential treatment facility for competency. And one, there's just a couple different pathways that they might take. One, if they're found competent after being in an RTF, well, then they might face various legal consequences for their behavior then. Two, if not, it might be dismissal. So they might dismiss and refer. So they might be evaluated for a potential Involuntary Treatment Act commitment, or they might just be released back out into the community. And in all honesty, that might take 27 different paths where you can connect the person, where they're willing to maybe go. So there's not always a kind of set route of this is what you're going to do, or even follow up. Where we've started to make a little bit of headway is you've heard of the contempt settlement agreement. If someone does go outpatient services, you do have a forensic navigator that's kind of the glue that's wrapped around them that also follows them 2 months or 60 days post completion of that program as well. So they're there to help facilitate, do warm handoffs, connect them, even sort of post the program. And of course, they may or may not be having to maybe go to jail or prison, depending on what that is. But if they're out in the community, you do have forensic navigators that are still with them for another 2 months. And so that allows them at least some continuity from like when they first enter the system to perhaps when they're at least leaving the system, criminal justice system, at least I would say, and now maybe they're connecting to their community-based support system. But no, there's not a nice pathway for anyone kind of anywhere. Because I'll be honest, one time a person might go through this program and maybe they had success, maybe they not, and then maybe the next time if they do come through, it's a different connection than what they did previously.
Thank you, Tom. Dan, Hamel?
Yeah, I just wanted to follow up on that a little bit. This is one of the most frustrating parts of the system for me is that it seems like everyone does really good work within the silos that they operate within, but there's a lack of sort of like the 40,000 foot view over all systems. And while we do fairly well in that we have a program called the GRACE program. It's ground level response and coordinated engagement. I think Melora Christensen might be on this call, and she runs that program, as well as the LEAD program, Law Enforcement Assisted Diversion. While people are in those programs, they have case management, they have the help that they need for whether it's basic essentials like housing or getting connected with an EBT card or whatever the basics are, as well as it's someone to connect with, another human being that's a positive person in their lives. What I'm concerned about is people exiting the system and beyond the limited assistance that's being provided. It's like it's you against the world, basically. And I really feel that that's where we could make some improvements here. And Whatcom is very different than many counties because of GRACE, because of LEAD, because of community paramedic program, a lot of housing supports with House Bill 1590 this last year. the Bellingham has a home fund, so there are supports out there. But I just see people getting lost and then committing another crime and then going back into the system. And God forbid they get addicted or connected with some of the drugs I described before. So I think and because this is a business meeting, because this is the behavioral health, and I chair that along with Mike Parker and legal and justice with Raylene and Arlene. I want to put a pin in this, and really, I know we're going to talk about reentry here in a bit, but I really think that we need to drill into this, and we need to have the overlay of the GARE, the Government Alliance for Racial Equity toolkit overlay over what we're doing, so that when we do it, we're doing it with an equity focus in mind, so that we really are, for lack of a better term, focused in on those pieces. Thanks.
Thank you, Dan. Back to Mike.
We are dominating this. And Raylene, please let us know if we're hedging on time. But this is really interesting, and it's great to have them here with us. We're aware that the Behavioral Health Services Organization, and Arlene could probably talk more about this, but we know there's dollars now available for some behavioral health navigation programs that are kind of starting out. Were these designed in any way in concert with you, or have I'm just curious if that's an opportunity that maybe we haven't had in the past to address a little bit of what Councilmember Hamill is talking about, which kind of a lack of navigation of all these complex services. And for folks that are obviously really beset by challenges, just got a fresh legal issue, and maybe they're out, and maybe they're exonerated of that particular issue. But we know that reentry and just getting settled back in is tough. Could you speak to that and maybe the new resources that you see coming on, and did they consult with you? Did they not? And is there still opportunities maybe to share, Thomas and Susan, some of your observations about that lack of that and how it might function well?
Yeah, so this is Tom. I would say definitely we get asked to provide information, recommendation, consultation on some of these areas for sure. Definitely the competency area, the NGRI area. So definitely your strict kind of criminal justice interpretation of some of those areas. As it expands out, as you're talking about more and more out into the community, that's probably going to be a bigger focus with the healthcare authority and less of kind of DSHS focus on some of those areas. But I do know, I think both Mike and Dan, you guys are hitting up good points of, we talked about our forensic navigators, and there are programs. I think you're spot on with the silos and saying, yep, did a great job in here, because that's what we would argue, like, oh, it did a great job at the RTF, but then outside of there, what happens? And so King County and others I know have, like, and maybe you guys do as well, but like what are called boundary spanners and stuff like that, that they're trying to be, again, that type of glue, because in some aspects, when you have a lot of services, you also end up being so siloed that you disconnect and people fall through the gaps, much like if you had no services. And I know that might sound weird, but that definitely is what we see in some of those areas where you can have 50 services and none of them talk to each other. And everybody's like, well, what happened to Tom? And everybody's like, I don't know. You don't have them, you don't, and there's just none of that connection. And so they are trying to look at the term that I've heard is like a boundary spanner, to try to say, how can you connect your lead to your grace, to your what other programs that you might have, to try to make sure nobody kind of slips through those gaps or cracks. So I might not have hit all of your question there, but that's kind of what we've been doing at this point, or what we're hearing from some of the other counties.
Thank you, Tom. Arlene? Arlene, you're on mute.
The conversation we're having is tremendously important, and I think it applies also to the other topics that we're going to be talking about today. This organization of task force has been meeting for years now and has been recommending changes, and some of those changes, such as navigation programs, are beginning. They're beginning. They are not fully realized yet. And the state is beginning to fund these programs, and the navigators, for example, are filling an important gap. Where, you know, we can see that in our conversation here. And our job in this task force has been to find where the gaps are and to make recommendations of change. So this conversation is our opportunity to recognize where they are. And those of you who are in positions to nudge these changes along will be able to understand what is needed and try to help provide that. So communication, obviously, amongst various programs, the fact that we meet like this is essential to the communication system that is lacking, and it produces a great deal of change. That is what is great about it. Then the second piece that's terribly important is that we need to fill the gaps with programs that are needed, or with more staff, because we have too long of a wait for treatment. And we know that waits are not good for people. It's not creating the kind of system that we really want to have. So I appreciate everybody who's here and talking today, and especially all the people who are here listening today, because we have the SAC program members listening too. Thank you.
Thank you, Arlene. Briefly, I want to discuss a little bit about what Eric Ritchie, Prosecutor Ritchie, brought up earlier. Is, you know, one of the key points of restoring somebody and determining if they need a cell order is community safety. And a lot of times the misdemeanors don't meet that level. But speaking from the small cities representative, a lot of times that's where they start. So we have people in the community that start with criminal trespass, which start with smaller issues that seem to escalate. And as they're waiting, as they're outpatient, and we haven't determined that they're a risk yet, or they can't be incarcerated because of certain conditions and COVID and all of that, what the small cities see in some of the limited courts of jurisdiction is that those individuals don't make it to court, or if they get to court, they might get some pretrial help through probation, they might get some mental health services, but they might not get that competency order, and then a felony happens, and then it is a community safety issue. So some of the things that I would like us to be thinking of as a group is, when it goes to the felony level, is this something the pretrial processes group should be looking at? Should they be making sure that some of this is happening if they end up going onto outpatient, if they stay on inpatient, making sure what they get what they need? Are these cases worth dismissing, knowing that there's been other cases that are being dismissed at lower levels because we're not getting the competency or the restoration? I have one individual that's been charged multiple times with domestic violence, no contact order violations. They all get dismissed, and he's never been restored to what I know of, but we still see continual cases. So you're never going to get that felony level necessarily, because all of the misdemeanor levels are getting dismissed because of the competency issue. So I want to make sure that we understand that sometimes the misdemeanor levels is just the beginning of the problem. The other thing I wanted to bring in Chief Jones, and we talked about this at the last Legal and Justice meeting. It was second Senate bill that's being proposed, 5664, concerns about that. And as I was reviewing that, and it was talking about outpatient competency availability, and then I want to say it was in subsection 17 that if somebody's not taking the medications and not following the requirements, that the department may authorize a peace officer to detain the
Raylene, you've gone mute.
Oh, I'm sorry. Can you hear me now?
Yes, thank you.
Okay. Where did you lose me?
Around detaining, peace officer detaining.
So on page 17 of the second Senate Bill 5664. This is a proposal, but it does talk about the officer being required to detain an individually that's not complying with the requirements into jail. And the last thing we really want to do is be holding all these mentally ill individuals into jail. And so I have concerns about this legislation, and I have concerns about not getting people out of the jail that need assistance. So if I could turn it over to Chief Jones briefly, if you have a moment to discuss what our current jail information is, and any other questions that anybody has for our fine panelists.
Well, I can certainly talk about kind of the status of the jail, and actually Jill will put up a graphic that if anybody finds it fascinating, we can send it out, but it just kind of explains the way the system's working right now. Ta-da! This was infinitely better, and I have to give credit where credit is due. I gave a mess to our community outreach individual, Deb Slater, and she cleaned it up so it makes a little bit more sense. Now, granted, this comes from the point of view of somebody who's involved in the jail. And so some of the attorneys may look and go, wait a minute, you missed a step, and any feedback would be appreciated because we can make this better. But I'll kind of walk through this relatively quickly, and then we'll answer any questions anybody has. We started from the point that somebody had come into custody and probably had their initial court appearance. Where you see the red clocks, that's basically because that's where we find that long pauses frequently take place, and we're not able to move people through the system. The first one for us is having the public defender, usually it's going to be the public defender, make a request for a competency evaluation. It's been more difficult with COVID because sometimes people don't present the same way that our deputies are seeing them on a day-to-day basis. We will be very clear, our MHPs will be very clear that we are dealing with somebody who has a serious mental illness. We're still trying to figure out a workaround so that we can, just as a matter of course, notify the public defender's office and say, by the way, your client is exhibiting symptoms that would be indicative of mental health issues. You may want to start addressing that with the court. We start bumping into HIPAA, and a lot of our offenders don't want to sign any kind of release of information. So that can be a pause. I've got at least 3 offenders right now that, in the opinion of the MHPs that work for the jail, are mentally ill, and their attorneys are not getting that same read. Now, the other thing that can happen is that when people are dealing with folks for the first time, they can pull things together. So it doesn't always, they're not necessarily exhibiting the symptoms that the deputies and the MHPs are seeing on a day-to-day basis in the jail. So we're still trying to figure out a workaround so that we can make sure the public defender's office and the specific attorneys have the same information we're picking up, both through incident reports and from the assessment process that folks go through when they come into jail. So let's make the assumption that in this particular case, the public defender has also recognized that their client is exhibiting symptoms of mental illness. They'll make a request to the court, motions go through. Most of the time what we get are stipulated orders that both the public defenders and the prosecutor's office agree that a competency evaluation would be a really good idea. Now, we do have to give the system credit, since we've now got the system set up so that those evaluations can be done remotely. They're actually usually falling well within the criteria that were established by statute and reinforced with TrueBlood. So we're not getting real long waits on the competency evaluation. The hitch we do occasionally get is that the inmate involved will absolutely refuse to talk to the evaluator. But they have that right. We would escort them, and the deputies will try to talk people into coming out of their housing unit and sit down. Excuse me just for a second. Thank you. I promise it's not COVID, it's just allergies. So let's say the evaluation takes place, the individual's been able to come up with an assessment. That report goes to, in this case, Superior Court. It's been forever since we've sent somebody down for competency evaluation or had one done up here for a misdemeanor offender. The report goes to the court and to the attorneys. At some point, they're noted up for calendar for a decision to be made at the court. And this is something a lot of people don't understand. The individuals who are the doctors or the professionals who are making the determination about whether they feel somebody is competent are giving a medical opinion. The decision about whether or not somebody is competent is coming out of the court system. So a judge has to make that decision. Now there is one, you see the arrows going up this way, the court can rule that somebody is competent and the case would continue through the criminal justice system. There is one thing that needs to loop back is that occasionally, it's something you see down here also, occasionally the public defender or the defense attorney will make the determination that they don't necessarily agree with what the judge is saying or what the initial evaluator is saying, because they're not able to get a level of cooperation with their client. So then they may either request another evaluation through the state hospital system or make the request and get an independent evaluation done, even at this point. Going along this way, because that's kind of the system we're talking about, is during this court appearance, the court rules that an individual is not competent based on the evidence that's been presented. Oftentimes now, it used to be that that decision was made and that was it at that court appearance. But the court system itself is working on some efficiencies. And so oftentimes this decision that somebody may not be competent, along with a motion for restoration, and sometimes even an embedded cell order, depending on what kind of history the court and all the attorneys have with that individual, is that we'll get the order for restoration, and that can be done on the same day. Cell hearings sometimes need to be separate, sometimes seem to be embedded in the initial motion for restoration. The next red clock you see is the wait period, and that runs from 12 to 18 weeks generally. Right now, I have 11 people who are waiting to go down to Western State. And the gambit runs from a wait of 9 days so far to a wait of 326. Now that is a fairly unusual circumstances, and he's fairly unusual individual, but I am also holding somebody who has been waiting for 223 days. He booked in on July the 5th. His bail is $100, but he doesn't have the money to pay for that. And so he's waiting to go to Western State for restoration. Individuals, once we get the order, we get a copy of the order, which is filed by the court. We did work with the public defender's office, actually, and the defense attorneys, because all of a sudden we were getting notified we needed to take somebody down to, frequently it's Western State Hospital. And we weren't even aware that there was a restoration order out there. So now what's happening when that paperwork is sent to Western, they simply fax it over to the jail at the same time. So that way they're on our radar and we're able to start tracking where they're at and to make sure that they don't get lost. We'll transport them down to Western State, and the amount of time can be anywhere from 25 to 180 days. It depends on circumstances. And the other thing that can happen is that on occasion, we will get paperwork indicating that the original restoration period has now been extended. It used to be that somebody had to come back to jail, then they go to court again, get resent down to Western State, which was cumbersome, involved moving an offender when they probably didn't need to be, and bollocksed up the system, basically. In the years that I've been really paying attention to this, which is around probably 20 or 25, I don't recall off the top of my head anybody who has been able to be restored to competency without medication. There may have been situations when they weren't in custody that they were able to do that, but by the time somebody gets here, generally the symptomology is so ingrained, it's very difficult to do it in any other way. And it is not unusual that people are compelled to take medication because they don't like the side effects. And a lot of our offenders don't believe that they have any kind of a mental illness. Once this period of time is over, they're returned to jail. The report is sent to the court and to the attorneys, and then we wait until it gets noted up. That can be a week or two, it can be several months, and a lot of that was difficult during COVID because, of course, the courts weren't working the way they had been in the past. We're starting to see things starting to speed up now, which is making it a little bit better. So they go for a court appearance, there's discussion about whether or not somebody is competent or not. The court can rule that they are competent, just like they were doing up here. And again, this is where the defense can make a determination that they're still not able to work with their client. And one of the things, because we're able to access the reports and review them, you can generally tell if this is a fragile competency, because the evaluators who are writing that final report to go to the court will make mention that this person is competent right now. That there is basically no guarantee that by the time they get back to the jail and or medication, which I'll talk about separately in just a minute, that they will stay that way or not. That their competency level and their control at this point may be so fragile it's going to fall apart before very long at all. And if you've got a court system that's backlogged, and ours is right now, it's nobody's fault except for COVID, but that has slowed everything down, which increases the probability that we may not be able to help this person maintain that competency level while they're in jail. And that comes down to this one right here. It is more common than not that individuals will start refusing to take their medication. Sometimes they won't take it from the very beginning once they get here. Sometimes it's a period of time and they will decide that they're feeling better and they don't need the medication after all. Now that is not unique to mentally ill offenders. We run into the same thing with people who are on hypertension medication, diabetes control medication. And in fact, from what I understand, it's a phenomena that physicians of all kinds are dealing with all of the time. Unfortunately for us, once somebody stops taking their medication, they will oftentimes quickly decompensate, and then we go back up to here again. If we can, we'll convince them if we can. There are also, if we can use long-acting injectables, the probability of getting them to continue that is higher, but there are some folks that cannot take those medications because they don't work. If the individual stays on their medication and is competent during that period of time, then it just switches over to the regular criminal case processing, and the competency issue is pretty much gone away. If the court initially back here determines that the individual still is not competent, most of the time there'll be a new motion and an order to send them back to Western State. The other thing that can happen here is that usually it's an agreed upon between the prosecuting attorney and defense attorney that this person cannot be restored to competency, or at least it doesn't appear that way. The charge may be dismissed and the paperwork and the process will get started for a civil commitment down to Western State or to another facility. This is what we're dealing with on a day-to-day basis. People get hung up, the red clocks are the biggest places, but this just getting someone from the report going to the players in that to getting them to court can be anywhere from days to weeks. It was for months. That seems to have gotten much better now that things have relaxed within the court system. But this is confusing, it's time intensive, and our facility does not have the competency or the ability to force medications because we don't have the resources available in the community. The other thing I'm hearing from a lot of folks is that that if folks are wind up doing jail time and then are released to the community, one of the things our nurses do on a regular basis is that when we are releasing an individual who's been on psych meds while they're in the jail, the nurses will go out of the front door shortly after the offender has left. And in about 85% of the case, we give the offender medications enough to get them till they can get to a provider. They will have thrown them away because they don't like the side effects. And when you feel fine, you don't necessarily acknowledge that maybe you need to keep taking your medication in order to stay that way. The analogy that I use most often is folks who are diabetic. A lot of folks have learned to tolerate high blood sugars. They don't like having to take the medication that will control the diabetes. And so they quit when they're not being strongly encouraged or sometimes compelled to do that. The other thing that we run into here is one of the reasons that people come into our system is because Raylene touched upon it. Oftentimes they're well known to the local police departments in the community. They haven't offended at a felony level yet, but oftentimes we'll get to that point eventually. That everybody who is in law enforcement, everybody at the emergency room identifies somebody as having a mental illness. But the criteria for involuntary treatment in the state of Washington is set very, very high. And most of the time, people don't qualify. And a lot of times their behaviors are such that the providers in the community will not deal with them. They have the ability, whether it's the stabilization center, whether it's the hospital, whether it's intensive outpatient, to say, no, we're not going to allow this person to participate in our programs or come into this building because of their behavior represents a danger to other people. And that's one of the reasons that approximately 40% of my population is diagnosed with serious mental illnesses. Schizophrenia and bipolar disorders are the two biggest. We're seeing an uptake in methamphetamine connected psychosis. We also have a huge number of offenders that fall in what I call the secondary category, and those would be personality disorders. But there aren't medications that actually are very effective for that. In fact, there are a few treatments that are very effective for that. So, and they generally fall outside of this system because for the folks who are, say, antisocial, they're very well aware that what they're doing is not socially acceptable. They just may not care. And actually, they do fairly well in a corrections facility because we can put some boundaries on those behaviors and enforce them. But once they're released out into the community, those boundaries are gone. I'm hoping this was as clear as we intended it to be, but if anybody has any questions or, what ifs or anything related to this or anything I've said, I'd welcome the opportunity to try and answer them. Mike, it looks like you might.
I do. Thanks, Chief Jones, for being here, and thanks for all the information. It's really helpful. I really like the graph. So whoever helped you, I'm a visual learner, and you provided a lot of information, and it was kind of complex. So I appreciate the visual. One particular thing that you said I was a little confused at, so this is really more clarification. You were talking about the ability of the jail to administer some medications, and you mentioned that we're not always able to because of a lack of resources. Could you speak more to what specific situations, medications, and what resources would you need to be able to have the coverage that you think that you need to?
Well, I mean, we can get the medication ordered. We can certainly try to persuade the offender to take it. But we have offenders who know that they should be on medication and absolutely flatly refuse to take it. In order for us to involuntarily medicate them, we would need to get an order from a judge. Then we would have to go through and fulfill, Raylene touched upon at the beginning of this, excuse me, the criteria that was established under the Harper decision, which originally came out of Washington State Department of Corrections. There needs to be people who have not been involved in the care, doing an evaluation to see if they agree with the involuntary medication. Then we've got to potentially hold somebody down in order to administer that. So there's this whole process we have to go through. When the last quarter of last year, we put out the request for proposal for psych services within the jail. We got absolutely 0 responses. And the dearth of professionals in this community that we might be able to access to fulfill that basically doesn't exist. And
So that's kind
one
of
the issue.
just to clarify, you're talking about like a missing psych consult in that situation. You've got
Well,
maybe
there's
the
a
order
whole-
that you need, just not a psych consult to be able to oversee the actual administration and the dispensing. or-
No, it's somebody, it is not just not a psych. It is a psychiatrist, a psychologist, and they cannot have been directly involved with the individual's care. And I don't have all the details because I just don't remember them. But the last time I looked through it, I went virtually, there's no chance a facility our size would be able to do that. As far as I know, the only place that is able to do outside of Department of Corrections, the only place I know that's 100% able to do involuntary medication is King County system because it's so large and it's the greater Seattle area, so they've got resources. But we just don't have individuals in the community. And part of that is because if we have to hold somebody down in order for you to involuntarily medicate them, because our folks, my deputies can't give injections, it would violate the nursing standards that my nurses are following. And so we start running into those kind of issues. We have been able to, on rare circumstances, when we had somebody that we knew we couldn't get temporarily released to hospital because the charges were too high, we were able to work things out with One Central, the docs at One Central up here locally. And we would transport the offender to the emergency room, and 2 of the physicians from One Central would come down, try to talk the individual into taking the medication, and then be able to make the determination they could involuntarily do it. But part of that has to be is if they can use the long-acting injectable medications. Right now, I'm working with one of the prosecuting attorneys here about an individual who only can take one type of medication that is only oral, that it's not made in an injectable one. And potentially the only way that once this individual came out of the hospital and back into a corrections facility, their history is that they will immediately stop taking the medication. And if they were able to get an involuntary med order, it would be a matter of holding the person down, putting a nasogastric tube in them, and putting the medication down that way. And judges are going to be a little bit less willing to do that. And so at this point, we're still kind of working our way through that process. But that's what I'm referring to. We've got a good prescriber. We've got some excellent MHPs who are very persuasive. And oftentimes that they can get people, and we can use some, I don't want to call it coercion, but encouragement. That, you know, if someone's not taking their medication and they're acting out in X, Y, or Z manners, that makes a difference on where you're going to be housed. That makes a difference in how much commissary that you can buy. That makes different on what resources you may be able to be access, like the tablets that we now have. Because we can articulate a legitimate reason why we wouldn't allow you to do that. Sometimes that works to help somebody cooperate with the healthcare staff and the psych staff. Sometimes it doesn't. So I've got folks in jail right now that are being housed in absolute hard isolation because I can't have them with anybody right now, either because they represent a health hazard to any roommates, or because they're too violent and they're acting out aggressively. Medication would help in all of those cases, but the offenders don't feel that they're mentally ill.
And so this interplays to some degree with our previous discussion of a cell order that had to do with competency restoration, but it sounds like it's also a separate and larger issue where you may have somebody who's maybe that's not under question, but maybe they would benefit from taking those meds and they're unwilling to do so. And it doesn't sound like currently then in Whatcom County, we have a good system to be able to help those particular inmates. And I say help because I've seen people so distraught and saying no to medication. I've also seen that same person after, and sometimes they can have a different view of it after being on medication. So I tend to view it as helpful, though not every situation needs that. But is my summation correct that we currently don't have a system in our jail due to resources of both personnel and maybe even program to be able to administer involuntary medications? Is that correct?
That's
Did I get that right? Okay.
That's
Thank you so much for your clarification. It's a little confusing, so I'm sorry if it seems like a pedantic question. But it's really
I'm just sorry if it was like a 5-minute answer to a 30-second question. Other folks on this panel probably know that I tend to do that sometimes. Darlene, you had a hand.
Hi, Wendy. You may have already summarized this, but one of the things I'm wondering, I'm on the Stakeholders Advisory Committee. And as we're looking at that for the new jail, I'm wondering if the concept of being able to hire somebody who could do competency evaluations up here is a possibility. I think it could help streamline the process somewhat. I don't know about medications. I don't even want to go there, but that's one thing that I was wondering if that's a possibility.
Absolutely, anything's possible, and it wouldn't, I mean, we basically are doing that now in this current facility. We're just doing it remotely. And so once we got that capacity, because with COVID, well, as all of you know, everything came to a screeching halt, every place. And so it took a while to figure out how we were going to work around that. And we've got the system set up. So like I'm saying, the state hospital system generally is more than meeting the mark as far as getting those evaluations done. Where sometimes we get a slowdown is when the report gets to the court, then the attorneys need to note it up for calendar. And probably the biggest thing that's most confusing to most people is that there can be a medical diagnosis that somebody is not competent, but until the judge orders that they are not competent, it doesn't matter. And so it's a matter of getting the report, having everybody review it. Hopefully everybody agrees. And then a legal decision is made in order to trigger the rest of that system. So, I mean, certainly more resources would be great. At this point, I wouldn't have the space to do more of them than we are, but we have been able to get them. Oftentimes it's in 48 hours once we get the order. So part of it is recognizing from the very beginning and figuring out a legal way to not work around, but acknowledging HIPAA and offenders' right to confidentiality, but also figure out a way that we can legally let defense counsel know your client, however they are presenting to you, is experiencing some very serious psychiatric illness symptoms, and you need to be aware of that. And at this point, we can kind of hint around or make some suggestions about, and the defense attorneys we deal with are very bright people. They usually pick it up, but not always. And so then it's, I don't want to expose, or my people don't want to expose the county to civil liability. So that's always a little delicate. If we can figure out a way, and I'll put the word out to some of the other jail chiefs I know in the state who have pretty excellent programs, and said, I'm looking for help, legal decisions you guys are aware of or whatever, as a better way of communicating that. Right now, if we have somebody who is hearing impaired or deaf, we're able to, in fact, we're required now to notify defense counsel and the courts and the prosecutor's office that they may need a translator. So, and I'm going, well, kind of the same thing, but different. But anyway, did that answer your question?
Yes, thank you, Wendy.
You're welcome. Anybody else? Really? Arlene.
Wendy, both from the task force perspective and for the benefit of the stakeholder advisory committee members who are listening in, I'm trying to get a handle on the scope of the problems we're discussing today. I understand the complexity and the many places in which complications could arise. But in the course of a year, how many people from Whatcom County are we running through the competency restoration process? And looked at another way, how many people are sitting in the jail at any particular time because of some of these issues?
I can tell you right now, I've got 11 people waiting to go. That I've got another 14 who are currently down at Western or Eastern State Hospital. I've got another 14 that have been down and have been found competent and have been sent back and are waiting for their court cases to get resolved. And in at least one case, one of them is probably going to have to go back. So my guess is between 50 and 75 people a year. The issue for us is that they take up, oftentimes will take up space that could be used for other reasons because they have to not have any roommates because of the acuity of their illness. And the other thing is that for my staff and for myself, for me, this is no different than if somebody was having a heart attack and refusing to go to hospital. The potential for somebody to die indirectly or directly as a result of this illness is actually very high. There is a phenomenally high correlation with suicidal ideation and attempts and somebody actually succeeding. Knock on wood, we haven't had any since 2018, but we've had some very serious attempts. And if it wasn't for the staff that's working at the jail and they're paying attention and understanding what the warning signs are, we may have had some fatalities. So that's part of the problem. And I think all of the people here understand that we're dealing with people that are very, very ill, but don't necessarily have a lot of insight to what's going on. Hopefully the medication will help them get that, but that doesn't even always work either. So, and we get caught in this loop. Raylene touched on it. I know Darlene and I have talked about it before because they start seeing them in the misdemeanor cases most of the time before they start hitting the felony side of the house. And when we go back and look at someone's criminal history, if they're not from the local area, you can see repeated police contacts where they've been arrested, and it'll be for things like trespass, disorderly conduct, fourth-degree assault. And you see the arrest, you see that they were booked and that the charge was dismissed. Then they were arrested and they went to court and charges were dismissed. And that's the kind of pattern you see in somebody who's mentally ill that has not been stabilized and kept stabilized in the community. I'll try to quit pontificating now. Does anybody else have any questions? Arlene, did you have one?
No, I guess my question really was, we're here to look at what's needed. And you've described the problems you're facing, but what do you need to change? What needs to be different?
I need to try and move people through these systems more quickly.
Okay.
I mean, I need to be able to figure out a way of giving their defense attorney a heads up that this person's mentally ill, so the sooner we can get the competency evaluation done and decisions made as far as treatment, the better that's going to be. If there are beds available for us to send people to for competency, that needs to happen. If they are indeed competent, they come back, they need to get in front of a judge, that decision needs to be made, and then the case needs to work its way through, not 6 months from now, but within a matter of weeks, if that's at all possible. And I can just feel both the defense and prosecutors are going, yeah, that's not going to happen. But part of the problem is the longer that they just kind of are there, the longer it takes us to get them through the system, the higher the probability that they're going to decompensate while they're in the jail.
And my hand isn't raised. It's a lot of these folks have really serious charges that require some investigation and development of their case, and they've been incompetent. So it's like starting from day one, even though they've been in waiting 9 months or 8 months or 7 months to get to, so maybe they've been in custody for a year going through this process, but it's as if we're meeting our client for the first time when they are restored in a position to do the very beginnings of a very serious case. So then there is this likelihood, strong possibility that they will decompensate, that they won't continue their medication. I mean, we certainly encourage them to and hope that they will so that we can help them. But that's how it looks from our end.
And I
So,
can understand that. Darla, you had your hand up, and then Jackie, I think.
Oh, yeah.
Yes, thank you. So I just wanted, I'm sure you all probably know about this option, but if someone is waiting in jail for admission to competency restoration, and this is kind of the flip side of the coin, if they're waiting in jail for competency restoration, they seem to be improving at that point. So maybe they've had time to detox or to have some improvement. Maybe they started taking their medication while they were in jail. We do have a process where you can request a reevaluation, and I'm not sure if you all are familiar with that, but the defense and prosecution can request a reevaluation of that person while they're waiting to be admitted for competency restoration. And that is one tiny little chip of a way that could move someone through the system more quickly so that they don't actually sit and then unfortunately decompensate while they're waiting. So it's a little thing.
In the very rare instance where my client self-restores, we use that, but it is extremely rare that a client self-restores. It does happen. Sometimes people in the jail environment are getting medications they were actually unable to get in the community and wanted to get. So then like, oh, well, wow, here I can get them now. Great, I'll start taking them. And then they restore themselves, but it's just not common. Thank you.
And part of that can be is that when we have them in a more controlled environment, especially since we've got a MAD or MOUD program. So if we can start dealing with that substance abuse issue and get that under control, and then they'll get a little bit more clarity and we can start really looking at the mental health part of it. But I would agree with Maya, it's a vanishingly small percentage. Jackie.
Yeah, Wendy, did you have a chance to look at Senate Bill 5664 and the fiscal note and all of that and determine if that would be helpful? It looks to me like it won't help your situation, but was intended to help your situation. So I just wondered if you had a chance to look at it. And
I did, but I haven't been able to take a look since legislation stopped, and I don't know if it ever got out of committee. The biggest thing was actually something that Raylene touched on, and that was that the police officers would go and grab on somebody who was not being compliant with the competency restoration orders that had come out. And I don't know where in the heck they think that they're going to go, because I don't have room for them in the jail. And this is not all appearances to the contrary, a psych hospital. And that simply because somebody's not been following, I realize it's a court order, but I've got 81% of my offenders in custody right now have serious felony charges. And so I wouldn't have room to be another involuntary hold place simply because somebody was not following the instructions for community restoration. So I was not, at least upon initial read, a real fan of that. But I don't know what happened to it, and I just haven't had a chance to look yet.
yeah, it made it out, and it does have a final bill, which didn't change at all. A final bill report and a final fiscal note. So
did it get passed?
Yeah, it's passed. Yeah, but it's not any different from what it was really when you saw it, I think.
Well, then I can't speak for the law enforcement side of the house, but I seriously doubt they're going to be real thrilled with that. So I'm going to have to go and double check.
Wendy, we're hoping to have some of our legislators at next week's task force meeting reporting on bills out of this session. If you could join us, that would be a great exchange to have with them, or Sheriff Elfo, or anybody else that could communicate the inadequacies of that attempted reform.
I'm not going to be in the office next week, Stephen, but I'm sure either the sheriff or undersheriff could probably speak to it because it's going to impact patrol, whether that's city of Bellingham, city of Blaine, or any place to that extent. And I'll make sure that I pull the bill and take another look at it. And not that I've ever been reticent about expressing my opinion.
I will be on vacation as well next week, Wendy, so if you could see if the undersheriff might be available and pass on the information.
I will talk with him.
Thank you.
No problem. So anything else?
I'd like to butt in a second, sorry. I really appreciate everything you've talked about, Wendy, as well as our other panelists, Darla Dawson, Susan Copeland, Dr. Negard, and I'm sure I slaughtered your name, so my apologies. And Tom Kinlan. All the information was extremely helpful. We have other items on the agenda, but I was kind of hesitant because I thought that this really kind of bled into some of our other issues. So I hope Dan and Mike aren't too upset with me for allowing this conversation to continue. Jackie, I hope that you and Susan can talk about some re-entry possibilities involving her in the future, because I think the two of you might be able to feed off each other and help this process along. By far, this is not going to be the last conversation. Dan and Mike and Arlene, is there anywhere you want me to go with the last 4 minutes on the clock?
Yeah, so I've got I've just been having an eye on the time too, and I was a little concerned, but I think the conversation, the discussion is very, very rich. And so I'm glad that you just kept it going. What I want to throw out there, if it's possible, given the time constraints of the work of the SAC, and just the limited amount of time that they have to work to put together a work product, and knowing that they're relying on us to some degree to at least gather information, if it would be possible for our two groups to meet again, instead of quarterly, but meet one more time to address the remaining agenda items that are on today's agenda. So what I would ask for is another meeting, another joint meeting in April for these two committees to come together. I don't know what the rules are, what the task force rules are, but there's so much rich content here that, and the timing is what I'm really concerned about. So that's my request.
Harry?
It's just to add to that, that's an interesting idea, Dan. And I wanted to also offer that there is a stakeholder advisory committee meeting set to just review some of the information for the Crisis Stabilization Center on March 30th at 3 o'clock. And so that piece of information will be obviously provided to the stakeholder advisory committee folks. So just wanted to throw that piece of information out there as well.
Okay, that could address, that is the next item on the agenda. So Perry, are you saying that information can be gone over at that meeting on March 30th?
Absolutely my intent, Mr. Hamill.
Okay, then the updates then would be the reentry services, which I think we could talk for an hour on, at least on that one, and then update on sequential intercept model, which I don't have a sense of how long that discussion could take, but I think it's worth it. I don't know who I'm asking, who the deciders are. I guess Raylene, Arlene, and Parker, and maybe Stephen, if as the co-chair of the task force, if you think that that's a good idea or not, or if we should just go back to quarterly and just pick up the conversation then.
Do we have to have a vote to do another joint meeting in the next month, or can the chairs just agree with doing the next meeting as a joint?
I don't see why you couldn't just agree to do that. I think that's a good idea myself, and there shouldn't be any impediment to trying to get the work done that you all are agreeing to do. I don't think, contrary to Perry's suggestion, that the SAC meeting on the Crisis Stabilization Center would add a lot to the two committees here on the task force going through the agenda necessarily. So I'd be in favor of Dan's suggestion myself.
Jill, next Can you, line judge Jill Nixon, can you tell us if that's okay?
Yes, that's okay.
Okay, sorry, Mike Parker, I cut you off. Maybe he got so upset he left. Sorry, Mike. Okay, well, then I think it just comes down to coordinating a time. We can meet during your time, you can meet during our time. I really don't, it doesn't matter as long as we get a majority.
I had a few individuals that weren't going to be available, I think, for our April meeting on the second week, which we normally have. So I'm thinking going to this time frame would be beneficial. If anybody else has any other points of view, please speak now or forever hold your peace until the next meeting.
So what date would that be?
It'd be the third Tuesday of April, I believe, and I don't have a calendar in front of me because everything else.
That's April 19th at 11:30 a.m. Is that what you're thinking?
Yeah.
Okay. I've got a couple of committee members who's got their camera on, so Lopez and Hilly, is that gonna work for you guys? Yeah.
Yeah, that'll work. We have
Okay.
a behavioral 9 a.m. that day as well, I believe.
Okay.
Tuesday,
Excellent.
19th. But yeah, that can work.
Okay, great. I just think that there's so much content here. Like I said, we've got a lot to go through. We also are at the end, we're over time right now, and we have not done public comment. And so I'm wondering if we can, and I saw there was one hand raised in the attendee pool. So are there other attendees that want to speak to the committees? Just raise your hand.
Any attendees would like to speak to the committee today, please virtually raise your hand now. And I do have one hand raised so far. Atul, I've allowed you to speak if you'd like to speak to the committee.
Sure, no, thanks. It's a great meeting. I'm learning a lot. Thank you all for doing this. And I just wanted to, as a member of the SAC, show my appreciation. And also that chart from Wendy. I don't know if that's available to the SAC, but it would be great if it was. Thanks.
For just to answer your question, I forwarded that chart to Kathy Halka, and I'm sure she can forward it to all the SAC members. I'll also be posting the handout on the IPRTF committee's web pages. And we have another hand raised, Belle Froby.
Hi there, this is Brel Froby speaking. I'm on the SAC. Also, just want to express appreciation for this information and for that chart. And I guess I have one quick question. This is going to show my ignorance, but on the flow chart, it looks like after someone has been stabilized or restored, that then they go back to trial, or that they're then prosecuted. Is that accurate? So like if someone's committed a crime and then and I guess my follow-up question is, and this might sound kind of naive, but like if the root cause of why someone committed that crime is mental illness, would it like is treatment? I mean, it seems like to me treatment then should be the solution rather than like further prosecuting, and especially given the point where where there's talk of being back in the jail has the risk of someone decompensating further, you know, especially in that delicate stage of just getting treatment and then going back to jail and then having to go through a trial and prosecution if they can't afford bail, et cetera, et cetera. So just any clarifying information on that would be helpful. Thanks.
Eric, did you want to touch on that?
Sort of. I just wanted to briefly say that it's more complicated than that. I mean, people who are mentally ill sometimes deserve prosecution, depending on the charge, depending on the facts. It's too complicated to just say mental illness is the reason, and therefore treatment is the answer. I'm just going to leave it at that.
Thank you, Eric. I know, just briefly, I got schooled on the difference between competency and insanity, and I can tell you that could be another 3-hour topic and conversation. So please stay tuned for more information from our committees and Behavioral Health Committee, because there's a lot to learn from everybody.
Are there any other attendees who would like to speak? And no more hands are raised.
Thank you all for your participation and joining. I hope that everybody can share information and try to make our system smoother in the future. If you have other topics that you want discussed at the next meeting or ideas to try to streamline some of these issues, please let us know before the next meeting in April. Otherwise, I think this meeting is adjourned. Thank you.